Una, daghang salamat usab sa walay puas nga suporta ug serbisyo ni USEC Josephus Pirondo Jimenez aron sa pagpaambit sa iyahang kaalam ug pagtabang sa atong mga estudyante. Hinaot paunta nga kanunay siya nga lagsik ug malipayon ug hinaot paunta nga ang tanan namo makatunan karon among mahinumduman ilabi na sa umaabot nga 2021 bar exams and beyond. Kini among giampo pinaagi ni Kristo imong bugtong anak hangtod sa kahangturan. Amen. Sa ngalan sa Amahan, sa Anak, ug sa Espiritu Santo. Amen.
I now turn over the virtual floor to USEC Josephus B. Jimenez. USEC.
Okay, good afternoon, and you can make me your co-host so that I can bring my materials. I welcome all those who are not taking the bar, but I have invited them coming from the industry. We have here with us many members of the HR community. There are company presidents. There are HR managers who are very they are looking forward to learn about the law and the decisions of the Supreme Court on three very important things. First is the issue of resignation. Number two is the issue of abandonment. And number three is about the issue of constructive dismissal. Constructive dismissal, because there have been a lot of decisions by the Supreme Court on certain resignations that have been questioned on the matter of voluntariness. There are employees who tender their resignation and then later on allege that they were forced, they were coerced, they were subjected to intimidation by the management, and that their resignation were not voluntarily given. And so today I will explain for the benefit of not only those who are going to take the bar, but also to those who are making decisions on hiring, firing, discipline of employees in the matters of the exercise of management prerogatives, especially that there are I will ask Attorney Wagas, our Associate Dean of the University of Visayas College of Law, Goliath Law School, to mute the others so that we can control the voice. No?
Yes, attorney. Yes, attorney.
Yeah, and also those who do not need to show their face, you can turn off your video so that we can save on the Wi-Fi, because the more people opening their video, the less would be the strength of our Wi-Fi connections. In the ASEAN region, no, by the way, among the 10 ASEAN countries, namely Singapore, Malaysia, Indonesia, Thailand, Vietnam, Cambodia, Laos, Brunei, and Myanmar, the Philippines is among the three lowest. No, even Laos is stronger in their Wi-Fi than the Philippines. Can you imagine that? So at this time of the pandemic, where we need this resource, in order to reach out to each other, there is a very strong imperative on the part of government to address this issue. So today, I will try to share with you my researches on the matter of organizational justice. This is talent acquisition for HR is hiring, total rewards is compensation and benefits, training and development. We are not going to discuss them. We are going to discuss organizational justice, and one of that, the aspect of organizational justice is the decision to discipline and dismiss certain employees who deserve to be dismissed under the law. So our topic is organizational justice, and with very specific focus on the three things, namely resignations, number 2, abandonment, number 3, constructive dismissals. So if you want to have a free video, you can just subscribe to my channel. No, that is the only thing I request you to subscribe to my channel, and you will get more than 27 videos of all the sharings that we had in the year 2020. Today is the first in the new year, and we begin the new year with a very controversial topic on resignation. So we will start with the definition of resignation. I have shown to you many of the books that I have written, and what I am going to lecture on are all in the books. So let us start with the definition of resignation. First of all, we should realize, ladies and gentlemen, that resignation is a right. In other words, you cannot prevent an employee who wants to resign. That is a right that belongs to the employee. Attorney Wagas, can you hear me?
Yes, attorney. Yes, attorney.
Okay, so I acknowledge the guest from the university. We have here today with us Attorney Edwin Estorgio, Attorney Sia Panilagaw, Attorney Michelle Amistad, and we have Miss Michelle Abella, the HR Director of the University of Visayas. For all of you who are attending today, the University of Visayas is the first university in Cebu, founded in 1919. We just celebrated our centennial. I was the president of the Alumni Association during the celebration of our centennial. I graduated from this university in 1974. Magna cum laude. Magyayabang ako ha. Magna cum laude and class valedictorian. And I took the bar without having to take the bar review because I could not afford to pay. All the bar reviews then were held in Manila. So to continue, resignation is a right. No, it is a right on the part of every employee. When the employee decides that it is no longer healthy, it's no longer exciting to work in a certain organization, he has the right to resign. But that resignation must be voluntary. It must not be imposed. Nobody, not even the employer or the Department of Labor, can tell you to resign. It's not like a public official where when the presidential appointees, they can be told by the president, tender your resignation or I will fire you. That is in government. But in the private sector, resignation should come from the decision of the employee. it should not be imposed because it is like a pronouncement, a formal declaration that I have reached the limit of my patience. I could no longer tolerate the situation, or there is a new, better challenge in another organization. I will live peacefully and harmoniously with you, but I say goodbye. It is my right. You cannot disapprove a resignation. Take note of that. Those who are representing the employers who are here today, I want to make this very clear. You cannot disapprove a resignation because resignation is a right. And if you disapprove a resignation, you are practically compelling a person to work against himself, against his will. And that is involuntary servitude. And under the Constitution of the Republic of the Philippines, involuntary servitude is not allowed. It is slavery. That is already abolished. Slavery is already abolished. So when a person resigns, you have to approve. There is no such thing as irrevocable resignation or revocable resignation. All resignations, it should be approved. You cannot disapprove a resignation. Ngayon, ang tanong, Sir, suppose pumirma yan ng design a contract to work with us for 2 years and we pay them 40,000 pesos like in the BPO or in the call center. Of course, ang tanong, can you disapprove a resignation because this person signed a contract? The answer is still no, you cannot disapprove, but the person must return the money. If he has already served, he signed a contract for 2 years, he served only for 1 year, he should return 1/2 of the money or proportionately, because nobody should enrich himself at the expense of the other. Every person in the exercise of his right and in the performance of his duty must act with justice, give everyone his due, and observe honesty and good faith. Article 19 of the Civil Code of the Philippines, which has a supplementary effect to the Labor Code of the Philippines. So again, I repeat that over and over again. Resignation is a right. You cannot disapprove a resignation because that is the right of every individual. Okay. The next definition is this is question. What are the usual reasons why employees resign? So alam ni Ning Adolfo ito. Those who are in HR, you know. Number one, this is based on survey. There was a survey made among 1,000 employees in 17 regions in the Philippines in the year 2020 during the COVID. They were asked, why did you resign? The number one, ang top question is this. They like the company, but they do not like the immediate superior. The culprit is the immediate superior. Those who are in HR should know this. Number two, they like the company, they like the superior, but the pay is not enough. Okay, so number two is money. Number one is relationship. Number three, they like the company and the boss and also the pay, but they do not like the work. In other words, the work is maybe hazardous to their health. The work may be not good for his condition or her condition, especially if she is pregnant woman. No. Number four, he does not like the company because there is no clear direction, especially with due respect, yung mga family corporation, iba yung utos ng asawa, iba yung utos ng husband, may mga anak pa, makialam. So, naguguluhan. So, yung iba ay umalis na lang. Number five, the employee is suffering from some physical or emotional stress. I will share with you the case of CyTel later on. 2020 case, CyTel, a very big company. Number 6, there are really legitimate reasons for resigning, like may green card na ako, or I have married a foreigner, or I have another job waiting for me, and better paying job. And number 7, the employee is under audit or investigation. I know that you will ask questions like this. Sir, what happens if an employee is under investigation and then he does not want to go through with the investigation? He just submits his resignation. What should we do? I have an answer. If I were you, do not disapprove the resignation. You just say, your resignation is held in abeyance. In the meanwhile, we have to complete the investigation, because if you are not guilty, okay, we will approve the resignation. If you are guilty, you don't have to resign, because we will terminate your services. Of course, the other company would say, bakit pa tayo mag-terminate? Kakasuhan pa tayo. Nag-resign na. Dapat i-accept na lang natin ang resignation. That is not a legal issue. That is a managerial issue. It's up to you. But from the legal viewpoint, I would prefer that all the just causes must be documented, because there are people who resign and you accept the resignation, and then later on they will file a case. Of course, sometimes naman they have the right really to file a case because they were subjected to unfair treatment. I know of a person who has been nag-follow up lang ng bonus, nagalit na yung may-ari. Tapos kung ano-anong sinabi, naiyak siya hanggang siya nag-resign. Or hindi siya nag-resign. Basta na lang terminate siya. So, yan ay mga katotohanan, and these are all based on statistics. So we will go to the next issue of constructive dismissal, because sometimes some people are forced to resign. There are people who are already presented with a prepared document. There is a resignation, you just affix your signature. No? It's management who prepares the resignation. Well, even if you do not resign, if you are subjected to very unfair situation, or you are demoted, your salary is reduced without just cause. That is in the eyes of the law, and this is in the case of Pascual versus CyTel, the case I referred to earlier. Decided in 2020, March 9. This is before the lockdown. And the justice who wrote the decision is from Davao, a justice from Davao, lawyer from Davao, whose sister is a commissioner, Socorro Inting. And the Inting family are very good lawyers, family of lawyers. Now here, this is a definition of constructive dismissal. This is the first kind of constructive dismissal, when there is a demotion or there is a diminution in salary. The second kind of constructive dismissal is when you are not demoted, your salary is not reduced, but you are subjected to insult. You are given an assignment that is very difficult. Para bang iniipit ka para mag-resign ka na lang, or you are deprived of certain status, no? The value of your position has been reduced kasi na-under ka na lang ng mga lower level of people, which is practically a demotion. But there are many kinds of discrimination. There are many kinds of insulting situation. And if you find yourself in a situation where your human dignity, demands that you have to resign in order to protect your self-esteem, that resignation is, in the eyes of the law, not voluntary, because it is you are not in control of the situation. You are just trying to protect your self-respect. No, so that is the second kind of constructive dismissal. The first kind is when there was demotion and there was diminution. Now, in the case of an OFW in Kuwait, and that I was assigned in Kuwait for 3 years, a very difficult country, a very small country with a population of only 4 million pesos, 4 million people, just like the whole island of Cebu. No? Ang Cebu nga, 5 million na 4 million lang buong bansa in Kuwait. Pero ang mga Kuwaiti is less than 1 million. All the rest are foreign workers, Indian, no, Pakistani, and then Filipinos. We have 265,000 Filipinos in a very small country. And here is a woman by the name of Hazel Biernes who was subjected to a very unfair situation by the employer. And she was compelled to sign a resignation letter because her passport was confiscated. Her telephone was confiscated. She was held incommunicado. So the only way for her to come home to the Philippines is to sign a resignation letter. And that was declared by the Supreme Court as the highest form of injustice committed against a very vulnerable person, a domestic helper from the Philippines by the name of Hazel Bernes. So, what are the usual reason why? What are the usual form of constructive dismissal? Demotion in rank, diminution in pay, discrimination, insult, unlawful withholding of salary. If you do not release the salary of your employee, the Supreme Court says that that is another form of implied dismissal. That is constructive dismissal, because the word constructive comes from the root word construe. It does not come from construct, but construe. In other words, when you say constructive dismissal, it is an act on the part of management that can be construed as a dismissal. Para bang hiwalayan ka na, binabastos ka na ng asawa mo, pero hindi lang niya masabi talaga yung salita ng hiwalay. So, binabastos ka, or yung mga damit mo itinatapon sa gate. Those are indications na ikaw ba bulag-bulag ka? Action speaks louder than words. Constructive dismissal, the other parlance there is action speaks louder than words. Constructive dismissals are actions on the part of management that are impliedly understood as dismissal. Pareho na tanggalan ka ng upuan. Ilipat yung table mo under the stairway. Binabastos ka ng employer mo. So if this happens to you, then that is already constructive dismissal. Okay? Abandonment. Okay. In fairness to management, there are really employees who just disappear for whatever reason. And then they do not call, they do not communicate, they do not answer any initiative to reach out to them. And then later on, they will come back and ask for a certificate of employment. Ito mga empleyado minsan. No, spoiler lang sa mga matitino. There are really employees who are like that. Pag nag-apply ng trabaho para maaamong kordero, then later on, I don't know. These are the reason why. Number one, they just stop reporting for work for no reason at all. Number two, they took a leave of absence, and after the expiration of the leave, they did not report for work. for a long period of time, more than 2 weeks already. You know, based on my readings of more than 1,000 decisions of the Supreme Court, when you say long period of time, it usually exceeds 2 weeks. 2 weeks continued absence. Can you imagine? If you are a rational human being with all the cell phones, all the gadgets that we have, you do not even initiate to tell your employer what happened to you, where are you, why are you not reporting? No, you might be stranded in an island, kidnapped, or you were already summarily executed because you were involved in drugs. No, but whatever, no, ayun nga pelikula ni Tom Hanks na Cast Away, if you remember, ilang taon siya nandoon sa isla, no? Hanggang yung asawa niya akala nagpatay na siya, nag-asawa uli, no? Ibang subject yun, family code yun. Pag bumalik siya at yung wife niya merong lang ibang asawa, sino ang may right sa babae? Yung original wife or yung original husband or yung second husband? The incumbent, madali lang sagutin yan sa mga yung family code because the law is very clear. Pag ang first husband mag-execute ng affidavit na I want to retrieve my wife, the first husband has the right. And what happens to the children kung nagkaanak na yung pangalawang husband? They are legitimate in the eyes of the law because they were conceived and delivered in good faith. In good faith, no? Para bang yung second husband ay builder in good faith, no? So walang masama yon. So pero kung ang tanong doon, paano yan sir kung hindi na mahal ng wife yung original husband kasi mas malaki itong second husband? Malaki ba ang sahod o malaki ang kanyang pag-ibig sa ikalawang husband? Ang sagot yan, kung ayaw na niya yung first husband, dapat i-annul muna nila yung first marriage. Or gagawa sila ng declaration of nullity kung i-approve sila ng court bago niya mapakasalan yung second husband. But anyway, that is not my subject. Ang subject ko labor, hindi family court. So babalik ako dito. Reason number 5. Some employees apply for work abroad. Pagkatapos, nung na-approve, umalis lang, hindi nagpaalam sa kanilang employer. Then later on, pag pumalpak sila sa Saudi, babalik dito. Ngayon, pag hindi na tinangkap ng employer, magpapahal ng illegal dismissal. Kasi in our country, wala namang bayad mag-file ng kaso eh. There is no filing fee. So, pakasakali lang makakuha ng separation pay. But if you resign voluntarily, you cannot ask for separation pay. Sasabihin na naman, they were compelled. But you know, if I'm the counsel for the employer, it's very easy. Record of POEE. The fact that you work abroad, and it's very easy to find the document from the Bureau of Immigration and from POEE, is the best evidence that you have no more intention to return. Because the elements of abandonment, there are 2. Number 1 element is you absented yourself beyond the period allowed by your employer. And number 2, you have no more intention to return. An intention, being a state of your mind, can be proven by overt acts and by obtaining an employment abroad or even in the Philippines in another company. That is the overt act that indicates that you have no more intention to return. No? Or number 7, you are only madly in love and has eloped with your lover and you forgot about your job. Tingnan mo naman. Yan ang mga responsableng mga tao. No? Attorney Wagas, 100 people na tayo ngayon. Take note. So today, I will discuss the following. Hindi pa tayo nag-umpisa eh. Opening remarks lang yung akin eh. Pag hindi natin matapos ito ngayon, next Monday, tuloy natin. Okay? These are the topic. Number one, what is the labor code provision about resignation? And what does the Constitution say about it? Number two, definition of resignation, resignation with just cause and without notice. No? There are situations in the Labor Code, Article 300, where the law allows an employee, even a housemaid, you can resign even if you do not give a notice. No? Binabastos ka na yung employer mo, sinasubject ka to a criminal offense, you can just walk away because this is with just cause, even without notice. That is allowed by law. Number four, what is the meaning and elements of voluntary resignation? With merong dalawang elements of involuntary resignation. And then number six, the forms and indicators of voluntary and involuntary. When do you say that a resignation is voluntary? And when do you say that a resignation is involuntary? Because when an employee files a case and then he is asked to submit a position paper, the company will naturally attach in the position paper of management the resignation letter. Why are you filing an illegal dismissal case when you resign? And then he will say, I was compelled to resign. It was not my free will. I did not sign it voluntarily. I was subjected to intimidation, coercion, deceit, gross misrepresentation. So many reasons under obligation and contracts vitiating my consent. My consent was not freely given. So the employee will say that the resignation is involuntary, and the management will say the resignation is voluntary. So they are now having a debate, and this debate can be resolved through evidence. And I will tell you tonight what are the evidence, to be used. So when is resignation tantamount to constructive dismissal? Yan. Number 8, burden of proof. So there are 8 topics. And if you want to have all this in the book, it is in the central bookstore. Written by father and son, JBJ and my son, JP. We co-authored a book, How to File and Handle Cases of Illegal Dismissal. So if you have this book, more than 1,000 pages, you have all the decision of the Supreme Court. If I'm the owner of the company, I really have to have this book. Last Christmas, so many companies bought books just to give as gifts to their friends, because books as gifts will be forever. Walang forever. Now, from management side, how to terminate employment legally and with honor and dignity. Sa employee side naman, kayo yung tinanggal, you will also say how to file cases and handle illegal dismissal. So, balance tayo, meron tayong management, meron ding labor. Sa mga estudyante, both, kailangan ninyo yan. So, we will start with the labor code. I told you about the provision of Article 300, formerly Article 295. An employee may terminate without any just cause. Without any just cause, but with notice. Tandaan ninyo yan, Pag walang cause, hindi ka naman inapi ng management mo. You want to resign? It's your right to resign even without cause. But you have to give notice 30 days in advance. But if there is just cause, you don't have to give a notice. No? Now, if there is no cause, and you want to resign, then you have to give a notice, because if you don't give notice, the employer can file a case of damages against you. Damages for what? Operation is derailed because you did not give notice, you just walk away. No? Pwede nating sampulan yung mga empleyado. Yung mga empleyado na balasubas na hindi na lang nag-walk away na lang sila, hindi sila nagpaalam, they can be sued for damages. Of course, it is an exercise in futility. Manalo ka nga, damages, wala naman pera yung kalaban mo. And nobody can be imprisoned for non-payment of that. Pero at least nabigyan mo siya ng leksyon. Nakagastos siya, kukuha siya ng abogado kasi depensahan niya ang sarili niya. Pinailan mo ng kaso. So it is written in the labor code that the employer can file a case for damages against the employee who resigns without giving 1 month notice in advance. See? But the resignation should be approved. Even if there was no notice, and the absence of notice does not mean that the resignation can be disapproved. The resignation you should still be approved, although the employee may be sued for damages. Because under the Constitution and the Bill of Rights, Section 18, Article 3, no involuntary servitude shall exist. Isa lang ang exception. Yung mga bilanggo sa bilibid, they can be forced to stay and even render work inside the jail. Kaya kung ako gagawin yung prison director, lahat ng mga bilanggo, trabahuin ko yan, patanimin ko yan ng puno ng kahoy para ma-reforest ang buong Pilipinas. Bawat isang bilanggo, di ka bigyan ng pagkain, di ka makatanim ng 10 puno ng akasya bawat araw. That is allowed by law. It's in the Constitution. That is the exception to involuntary servitude. So ba't hindi natin gamitin yan? Lahat ng bilanggo, patanimin mo na 1 punong mangga. Lahat ng bundok ng Cebu, punuin mo ng puno para pakainin mo yung mga bilanggo na yan na walang ginagawa sa bilangguan kundi magsyabo. Okay, definition of resignation, I have already explained that. I don't have to repeat. Suffice it to say that it is voluntary. It comes from the mind of the employee. It is not imposed. No? Resignation, no? It is a formal pronouncement. Ibang sabi mo, ayaw ko na. Para bang sa mga Muslim, pagka gusto nilang i-divorce ang asawa nila, sasabihin lang niya na, I divorce you, I divorce you, I divorce you. Tama na yun. Hindi yan kailangan mag-file ng annulment sa mga Muslim. No? Ipa-register mo lang yung word mong I divorce you. Tapos na yan. Pwede na siya mag-asawa. No? Sumubra pala 5. No? So, resignation is a formal pronouncement. It is a declaration of what you think. Na, I am relinquishing this office. So there are 2 elements there. The declaration to relinquish, and number 2, the overt act of relinquishment. So the declaration says, I resign. And second, malis ka. Hindi yung mag-resign ka pero nandoon ka pa rin, nag-opisina ka araw-araw. Because that is the overt act of resignation. As to the constructive dismissal, there are 2 kinds. Number 1 is demotion in rank. Number 2 is diminution in pay. And the third is the discrimination insensibility, disdain, mga insult, nandyan. Okay? So what is the meaning of involuntary resignation? Well, even if you declare, nag-declare ka na nga na mag-resign ka, pero hindi talaga yan ang bugso ng damdamin mo. That is not the spontaneous expression of your will. You are only compelled to do that in order to save your human dignity, your self-esteem and self-respect. You are just compelled to resign against the better judgment. Para bang sinasabi mo, I do this against my better judgment. Para bang uminom ka ng apdo, yung bang iniyarok mo yung napakapait na poison, no? Because it's better na mawala ako sa kampanya ito kasi hindi ko na kaya araw-araw, nilalait ako, inaalipusta ako, niyuyurakan yung aking dignidad, wala na akong mukha, pati ako, hindi ko na respeto ang sarili ko. That is involuntary resignation. No? Kaya, alam mo, minsan, pumipirma ka ng papel, umiiyak ka, hindi mo pala kagustuhan yun. No? So, later on, kuan mo yan. You retract what you have said under oath. So, again, the elements of resignation. Number 1, declare the intent to relinquish. And number 2, overt act. Una muna, salita, sunod, action. No? The action, primero, the decision, sunod, the words, then third is the action. The decision is to leave. Declare it in writing or verbally. By the way, there is no law that says all resignation must be in writing. Although nakalagay sa Article 300, no, na you have to anong sinabi? You have to serve a written notice. But the service of a written notice, if it is absent, no, is substituted by your act of walking away without writing it down. That is abandonment, tantamount to voluntary resignation if you were not subjected to injustice and insult. No? So, kailangan alam nyo ang mga element dito. Meaning of involuntary resignation. Harsh, hostile, unfavorable conditions set by the employer. Alam mo ba itong mga words na ito? These are not my words. These are the words of the Supreme Court. In the case of Pascual versus CyTel Philippines Corporation. Bagong kaso, mainit pa. Wala pang 1 year, no? March 9, 2022, no? Before the lockdown. Definition, but this is quotation of past decision. Hindi yan original ni Justice Inting. Okay. Listen to the facts of the case and learn from it. Learn from them. Mr. Pascual was hired by CyTel in 2006. He worked there for 8 years. In 2014, he was promoted. Ito yung promotion na hinog sa pilit. Because parang hindi handa itong tao ito. Hindi siya handa. No? And then when he was told by management, Mr. Pascual, now that you are supervisor, you have to coordinate with the other team, the quality team, the operation team. You have to have good relationship. But maybe he was not prepared for the bigger responsibility. He kept on absenting himself. And so he was, after the promotion, he was suspended for being absent without leave. And then maybe he was shocked. He did not expect that he would be suspended after the very happy promotion ngayon, suspension. Parang the agony and the ecstasy. And then, nagsalita pa siya, mag-resign na lang ako dito. No? Promote kayo. Pagkatapos, pahirapan niyo ako. No? Pero hindi siya sumulat. He did not write. He just declared. No? And then, sabi niya, sige, bigyan na lang niyo. Give me certificate of employment. I will apply in another company. Because I feel that, I'm not accepted by the others as a supervisor. So I am under stress, physical, emotional, psychological. And then when he declared that he wanted to resign, he again absented himself. And his salary was withheld by management. Now the question, because he filed a case of, wala naman siyang natanggap na termination. He was not even subjected to investigation. He was only suspended because he was made to explain why you were absent. He could not explain. He did not explain. He was asked to come. He did not appear. I just went to the Dole NLRC and filed the case. So this is the story. This is his story. Story niya ito. This is the version of the complainant. Mr. Carion, can you read this, Mr. Carion?
USEC, wait. Mr. Pascual's story. He alleges that he was pushed to a situation where the oppressive and demeaning acts of management created by the company created an adverse working environment, rendering it impossible for him to continue with his work. He alleges that his severance from employment was involuntary, but was the result of forceful withholding of salaries. He said that he was intentionally coerced into giving up his job. He alleged that he was unjustly suspended when he asked for details why his salaries were withheld.
Okay. So ito naman yung story ng management. Basahin mo yung story ng management. Basa, kapatid. Kapatid na Carion. Basahin mo.
The management, here is the management's version. When he was promoted to supervisor, he was instructed to coordinate with the quality team. He ignored the instruction. The company charged him of negligence. He refused to attend the admin hearing. Management countered that there was a just cause to terminate this employment.
So ito
The
na.
decision, okay,
Sige. Thank you.
sige,
Thank you, Mr. Carion. Ako na.
okay.
The labor arbiter, because he filed a case. Alam mo ang desisyon ng labor arbiter? Sabi ng labor arbiter, you were not dismissed. You were the one who declared that you want to resign. And then you did not attend. You were called. You did not attend. So why are you filing a case of illegal dismissal? So the complaint was dismissed. And the dismissal of the complaint was affirmed by the NLRC. So when you lost your case before the NLRC, you have to file a motion for reconsideration within 10 days from the time you receive the order or the decision. So Pascual filed an MR or motion for reconsideration. The MR was denied. So Pascual went to the Court of Appeals under Rule 65 of the Rules of Court. You have 60 days, longer 60 days. Mantala from arbiter to NLRC, only 10 days. Dito is 60 days. And the ground is grave abuse of discretion. So the issue before the Court of Appeals was, did the NLRC abuse its discretion when it dismissed the case of illegal dismissal? The Court of Appeal said, no, the NLRC decided correctly. Pascual really intended to resign, and he did resign. He's not coming to work after saying that he wanted to resign, fulfill the two elements of resignation. When he declared, even if not in writing, that he wanted to resign, that was the declaration of intention, the formal declaration of severance. And then the refusal or the failure to report for work was the overt act of relinquishment of his position. So the two elements of resignation were fulfilled. Okay? So, and then the Court of Appeals decided against Pascual. Ito, talo siya all the way. Talo siya sa arbiter, talo siya sa NLRC, talo siya sa Court of Appeals. Nag-file siya ng MR, Motion for Reconsideration, Court of Appeals, denied. So go to the Supreme Court. You have 15 days only. Rule 45 of the Rules of Court. Petition for review on certiorari under Rule 45. And the ground, only one ground, question of law. You cannot raise a question of facts. The finding of facts of the Court of Appeals being synonymous with the finding of facts of the arbiter and the NLRC can no longer be changed by the Supreme Court. It is binding on the Supreme Court, questions of facts. The only question raised should be question of law. And on question of law, the Supreme Court also said that Pascual was not dismissed. He was not subjected to constructive dismissal, that he voluntarily resigned, and there was no illegal dismissal. Therefore, the case should be dismissed all the way. 4 levels, arbiter, NLRC, Court of Appeal, Supreme Court. This is the case of CyTel and Pascual. So, can you read that, Mr. Carion? No, the Supreme Court?
Yes,
Ikaw
Yusek.
ang assistant professor ko kasi maubusan ako ng boses.
Okay, Yusek. The Supreme Court held it decided in favor of management that there was no constructive dismissal, that the employee was not dismissed. He resigned. The Supreme Court emphasizes that the constitutional policy to provide full protection to labor is not meant to be a sword to oppress employers. Indeed, the commitment to the cause of labor does not prevent us from sustaining the employer when it is right.
So you hear that the maxim which says that protection to labor should not mean oppression of capital, because you should not kill the ghost that lays the golden egg. Employers also have certain rights. Employers have certain prerogatives. And if you deprive the employer of the prerogative to discipline employees, you are also depriving them of their right to property. This, you know, in your study of property ownership and its modification in Book 2 of the Civil Code of the Philippines, one of the attributes of ownership of property, when you own the company, and we have among our audience now owners of company, when you own a company, you have the right to hire, to fire, to transfer, to promote, to lay off, to discipline, as long as you do that within the framework of the law and you follow the procedure, due process, then you will be protected by law. Because when the state is mandated to protect labor, it does not mean that labor can abuse, that labor can just violate the rules. Or in this case, his right was not violated. It was he who was challenging the authority of the company. And he did not follow the instruction to coordinate with the quality team. He ignored. Then he absented himself when asked to explain. He did not respond. He was called to an admin hearing. He did not attend. So what shall you do to this kind of employees? No, this employee, no, employees also should be aware of their obligation to the employer. It's not just one-sided that they will demand for all the wages, benefits. The law is very strict against management. So in fairness to management, the employees also must perform their duties and obligation. They are also covered by Article 19. Every employee in the performance of his, in the enjoyment of his rights and in the performance of his duty must act with justice, give the management its due, and observe honesty and good faith. Because in the absence of that, there may be a just cause to terminate the employment. See? So if you want to have a copy of this, don't take notes. You just subscribe and get a free video, 27 videos for you. Okay. Resignation. When can you resign? Without just cause, but with prior notice. Any time you can resign. No? An employee may terminate without any cause, anytime. If you do not want anymore your job, you can tender your resignation. The only thing that is required of you is to give an advance notice, because management has to find a replacement. Management cannot afford to derail its operation. You have to turn over the documents. You have to clear yourself, get a clearance, and then get your whatever proportionate 13-month pay or your encashment of vacation leave and sick leave. That's all. You do not have separation pay because under the law, if you voluntarily resign, you are not entitled to separation pay. But if there is a company policy or a collective bargaining agreement that grants separation pay, even if you resign, so be it. If there is a retirement plan, no, early retirement program, you can avail of the early retirement program, just like the case of the University of Cebu, which which I discussed earlier, about a faculty member in UC who was teaching in the college, and at night she was studying in the College of Law, and she became a lawyer. When she took her oath, after that, she decided to avail of the early retirement program. Well, it was approved by the administration of UC. The only question there was the amount of retirement pay. And the employee won her case. You know, that lady lawyer, she was a new lawyer, and the first case that she handled was her own case against the university, and she won. She won in the arbiter, but the NLRC reversed. She lost in the NLRC. Then in the Court of Appeal, she lost. But when she brought the matter to the Supreme Court, she won. No? And she was granted the maximum retirement benefits according to company policy. According to company policy, the university manual policy. When there's a dispute, there is a conflict between the labor code provision and the provision of the manual, the one that grants the higher benefits will apply. Hindi yung sabihin mo kaagad, batas ang mag-apply dyan. Kung mas mababa sa batas, the law will always give the one that is higher. No, because, a policy of the company that is accepted by the employee over a period of time, it becomes embedded into the contract and it becomes a company benefit that cannot be withdrawn unilaterally, as decided by the Supreme Court in many cases that unilateral withdrawal is not allowed. No? Ang withdrawal, pwede yung withdrawal basta pinag-usapan. Pero yun ang kaso ng hotel, the waterfront hotel, Insular Hotel, waterfront in Davao, where there was a diminution of salary and benefits. But it was a diminution that was negotiated. It was not imposed. Ang bawal lang dyan, kung unilateral, sasabihin ng management, bawas na yung sahod nyo kasi COVID tayo ngayon. Kailangan bawasan yung sahod nyo. Pag hindi pumayag ang empleyado, kakasuhan yan, that is a diminution. Pero pag nagsabi ang empleyado, sige ma'am, papayag kami, we agree because we understand during a time of crisis, kung maiksi ang kumot, matutong mamaluktot, we have to share our pains together. There's nothing wrong. That's not contrary to public policy. That is the decision, not only in Insular Hotel, but also in the case of Philippine Airlines. No? So that is now we go to the next topic: employment, termination of employment with just cause. No, without just cause. No, without just cause, there must be notice. No, but no, the failure to give prior notice does not mean that you can disapprove. Only it gives the employer the right to file a case for damages. No, yan, simple lang yan. Magkano naman ang damages? The law is silent on the matter, and it is presumed that the damages means actual damages. So this is a matter of evidence. How much did management suffer? In the law of kasambahay, yung mga maid, pag ang maid mag-walk out without prior notice, ay hindi naman sinaktan ng empleyado, ng employer, merong sinabi ang kasambahay law, 15 days of his salary, her salary can be withheld by the employer. Yung regular na empleyado sa is not explicitly provided. No? The obligation to reimburse the employee to pay training costs. This is very good. If you train the employee and then the employee sign a contract that because you trained me like this pilot, there are 2 pilots in the Philippine Airlines. Pilot Almario and Pilot Eliher. No? And this reached the Supreme Court. Si Almario pinabayad ng PAL ng 851,000. At si Eliher pinabayad ng 559,000. Mahigit. Bakit? They were trained, no? They were trained. Pinadala sa US in order to know how to fly the 747 Boeing giant aircraft. And they were made to sign. The company will invest in your training. So you have to sign that you cannot resign for a period of 3 years. 3 years nga lang hiningi sa kanila eh. Because the law does not allow unreasonable length of time because practically that would become involuntary servitude. So, ngayon, itong mga tao na natuto na pinadala sa Texas, nag-aral sa Alabama, sa Texas, kung saan-saan, sa Minnesota, tinitrain sila ng Boeing doon sa Seattle, sa state of Washington. Ang laki ng gastos ng PAL. No? And so, perma sila. Pagdating nila dito, nag-serve sila. But itong Qatar Airlines, which is the richest airline in the whole world, Qatar, a small country, is the richest country in the whole world in terms of GDP per capita income, $132,000 for every Qatari. Can you imagine that? The richest country is Qatar. Hindi US, hindi Germany, hindi Russia, Qatar. In terms small population, big economy, natural gas, grabe ang Qatar. So itong si Almario at si Liher, sinabi ng Qatar Airlines, transfer to us, we will triple your salary. Lipat sila, kinalimutan nila yung piniramahan nila. Well, siyempre, ang PAL hindi naman tanga yung PAL. So nung kinompute yung kanilang retirement, malaki naman ang sahod ng mga pilot. Mga pilot, 300,000, 250,000, mga pilot. Yan nga sinabi ko sa mga estudyante ko sa College of Law. Kaya kukuha pa kayo ng law, hirap-hirap ng law. Mag-pilot kayo, wala pang bar examination. Gusto nyo mataas ng katungkulan, 37,000 feet above sea level, mataas na katungkulan. Yun ang kunin nyo. Biro lang yun. Kasi ito si Almario at saka si Liher. Pinabayad ng PAL ngayon, nag-file ng kaso. Eh di nadagdagan pa yung bayaran nila. Nag-file ka ng kaso, dagdagan pa yan ng 6% interest plus attorney's fees. So, lumaki pa yung bayaran nyo. Nakatanggap na kayo ng sahod sa Qatar Airlines, sobrang laki-laki ng sahod nyo, triple. Tapos ayaw nyo isauli yung training fee ng management. That is also undue and unjust enrichment. Every pilot in the exercise of his right and in the performance of his duty must act with justice, give everyone his due, and observe honesty and good faith. Tinitrain kayo ng management. Pagkatapos gagamitin ninyo yung kaalaman nyo sa competitor. Doon kayo sa competitor magtrabaho. Kawalang hiya naman yan. So, the law is fair also for management. Magbayad kayo. No? Kung hindi kayo magbayad, ang tawag sa inyo, who does? Who does not pay? No? It is the employer, not the resigning employee who has the right to insist on. So, kung mag-resign kayo, sabihin mo, Ma'am Valerie, mag-resign ako. Magbigay ako ng 30-day notice. Kung sasabihin ni Ma'am Valerina, hindi na kailangan mag-30-day notice ka, effective na kagad bukas. Matagal na ako nagdasal na mag-resign ka ngayon. Finally, nag-resign ka. Ngayon, illegal ba yon na sinasabi na hindi ako binigyan ng 30 days, ineffective ka agad ni Ma'am? That's not illegal. Because the 30-day notice is not the right of the employee. It is the right of the employer. So if it is the right of the employer can waive it. Okay, sabi ng employer. Kaya lang naman nagsabi ang batas na I must have 30-day notice so that I can find a replacement. But you are a very easy person to replace. Because your job is very easy we can source immediately. There are others waiting to take your position. So pag sinabi mo, you are resigning effective 30 days, I can respond to you. Your resignation is accepted, effective immediately. Oh. Yan ba? Illegal ba yan? No. It is the right of the employee. Pwede nga niya, okay, 10 days, imbes 30 days, 10 days, surety niya. That's the call of the employer. That's not the call of the employee. No? Pero ang masama naman yung nangyari sa General Milling Corporation sa Cebu. Bakit? Hindi yun resignation kuan yun retrenchment. Ang ginawa naman ng management, nung nag-declare ng retrenchment, hindi na pinapasok yung mga personal belonging niya sa kanyang table. Hindi na niya makuha kasi the guard were instructed not to accept, to admit. So nag-file lang kaso, nabigyan pa ng damages. Ang pangalan si Miss Bihar. Alam ko yung kaso na yun kasi ang abogado niyan, si Attorney Ramil Sungkad, taga Ronda. And ako naman ang, yan si Ramil Sungkad, that is my apostle. Ako naglagay sa kanya sa Pepsi Cola. I don't know if Ramil Sungkad is here. Kasi si Ramil Sungkad, nakapanalo kagad ng kaso yan sa Supreme Court. Sister-in-law niya yung kanyang kliyente. Ewan ko, binayaran ba siya? Basta nananalo sila against management. No? Okay, number 3. Resignation with just cause without notice. If any of this will happen, the employee can just go without notice. 1, serious misconduct by the employer against the employee. Example, serious misconduct. During the Christmas party, no, when the general manager was delivering his speech, she mentioned an incident and blamed Mr. X to the great embarrassment of Mr. X. In front of all the officials and employees. And that was a serious misconduct on the part of the employer. And the employee can just walk away to save his face, to save his self-respect, because that was a just cause that calls for a termination by the employee without prior notice. No need for 30-day notice. Yan, inhuman and unbearable treatment. Commission of a crime, for instance, sexual harassment. When the employer commits sexual harassment, and you know the definition under Republic Act 78-77, the Anti-Sexual Harassment Act, there was a case involving Waterfront, the Hope, when a manager was accused by a job applicant, remember, job applicant, not an employee, job applicant. And this person was claiming that he could facilitate the acceptance of his job application, brought the job applicant to a room and asked the job applicant to touch his private parts. No? Can you imagine that? That is sexual harassment, asking for a sexual favor in exchange for a favor regarding hiring, promotion, training opportunities, salary increase. Another employee of the hotel was not the employee of the hotel, but the employee of a shop renting a space in the hotel, selling branded goods. And there was a beautiful lady, and that lady was subjected to the same acts, even inside the elevator, touching the sensitive territory in the anatomy of the woman. And that was the woman complained. Like the job applicant also filed a complaint. The question was, can sexual harassment be committed against another person who is not an employee? And the Supreme Court said yes. The Supreme Court said yes. And there is no place for a manager of a company to continue employment with that kind of behavior. No? So I mentioned that in relation to termination by employee. Now, if the employee in that case walk out of her job because she was subjected to sexual harassment, if she was already an employee, well, could she be sued for damages? No, because there was just cause. No? If any of this just cause, now remember, ladies and gentlemen, under Article 297, just cause naman ito for the employer to terminate the services of the employee, like serious misconduct, insubordination, fraud, gross and habitual neglect of duty, crime against the person of the employer, immediate member of the family of the employer, or duly authorized representative. But here it is the serious misconduct of the employer against the employee. In 297, it was the serious misconduct of the employee against the employer. So the employee also can terminate the relationship. No? So what is the meaning of voluntary resignation? I have already discussed that. I have repeatedly discussed that. So, you know, the secret of learning is repetition. Evidence of voluntariness of resignation. So if you are the employer and you prepare a position paper, and the issue is, was the resignation voluntary? Well, number one, she was the one who prepared that in her own handwriting. That is a good evidence. Mabuti pa nga yung mali ang English kaysa napakagandang English prepared by the lawyers, and all that she did was to affix his signature. Pagka nakatype yung resignation and it is couched in a very legalistic term, that will be seen with suspicion by the Supreme Court. But if it is in the handwriting of the employee and the English is very problematic, well, the Supreme Court is not a grammarian. It does not care. What is important is this really the will of the employee? No? Buti pa nga yung magkamali-mali kasi maging totoo eh. The error is an indication of the truth. Then, pumirma pa siya ng quit claim na she received the separation pay. Then, ang educational attainment niya, college graduate siya, PhD siya, tapos mataas pang ranggo niya sa kumpanya. Paano siya iyan makakasabi na hindi ito pinilit na ako mag-resign? It's very difficult. Especially if you're a lawyer. You know, later on, I'll tell you, there is a case about Globe Telecom, and the manager of the legal department, a lawyer, was suffering from a difficult pregnancy. No? Later on, then she tendered a resignation. Pagkatapos, after that, nag-file ng case illegal dismissal kasi daw na puwersa lang siya. But she is a lawyer. You know, if you are a lawyer, napakahirap na i-convince ang judge na naloko ka. How can you tell the judge na hindi ko po naintindihan, lawyer ka, saan ka ba graduate, buang ka? Saan ka ba? Bakit ka? Why did you sign that? You prepared that resignation in your own words. And then later on, you will say that you were misled, but you are a lawyer. You are supposed to know the implication of what you are doing. Kaya ako, ilang beses na ako naloko ha, pero hindi ako nag-file ng kaso. Naloko na ako. Manloloko sa akin, mga ordinaryong tao lang kasi madali akong lukuhin, madali akong mga paniwalaan. Pero hindi ako nag-file ng kaso kasi alam ko, paggalitan na ako ng judge, sabihin, ikaw, graduate ka ng UV, magna cum laude ka pa, professor ka, you are an author of books, pagkatapos sabihin, naloko ka, buwang ka. No? Yan. So, yan para magiging liability mo pa yung high educational attainment mo. Yan sinasabi ko sa inyo eh. Be careful when you make allegation kasi baka baliktaran ka pa, under oath pa na yung sinasabi mo. Sabi mo na. At saka nakakahiya sa ibang mga abogado. Pag nakita, abogado ka, you are a brother in our profession and then you are saying that you did not understand. Ano ka ba? Nanluloko ka yata eh. No? Okay. What are the indicators of involuntariness? Ito. Ang unang tanong, should resignation be in writing? Well, if it is without cause, it says you have to write, no, you have to inform management 30 days in advance in writing. But if you declared verbally and you did not write it, but you actually left, like in the case of CyTel, kahit pa sinabi ng batas na in writing. Pero ang sinabi kasi dito, without cause. Doon sa CyTel may cause yun eh. So, here there are acceptable exceptions. No? Exception to the rule that requires written resignation. A verbal or oral resignation tendered by an employee, which is immediately accepted by the employer. Ito take note ha. To all of you who are listening to me, if your employee verbally resigns and you really do not want him to remain, if his resignation is verbal, you answer in writing. You say, this is to confirm that we are accepting your verbal resignation immediately, because if you do not do that, tomorrow she can retract and say, I take back my resignation. Anyway, you have not accepted it. They can still retract their resignation before you accept it. But the moment you accept a resignation, it can no longer be retracted. There is already a meeting of the minds. So, that's why the word used is tender. There is a resignation that is tendered. So I tender my resignation verbally. You accept it in writing because management would like to protect itself. Protect itself because later on, verbally or in writing. Now, you have accepted it. No, you say, as of 4:30 in the afternoon of January 4, you have tendered your resignation verbally in the presence of the following witnesses. Please be informed that management is accepting your resignation effective immediately. Sign, then you serve it. See? She can no longer, or he can no longer take back because you have already accepted the resignation. This is what happened in the case of Hitsanova versus Attorney Madore. Attorney Madore is an associate or an employee of a law firm. I know this law firm because Hitchanuba, the woman, is a very prominent member of PMAP before. We are very good friends. And she has transferred from HR to being a full-time lawyer, and she put up her. And one of the lawyers that she hired as an employee, not as an partner, not as a partner to the law firm, but as an employee. So this lawyer, Lini Maduri, one afternoon approached the managing partner, Attorney Chanuba, and said that I am resigning. I am giving back the records of the case. No? Then Chanuba, being a brilliant lawyer, signed the acceptance in writing. And then two days thereafter, Maduri said, I retract my resignation. And when she was not accepted anymore, she filed a case and she lost the case before the Supreme Court and said that the resignation verbally made can be accepted in writing. It is valid, binding, and effective. No? Mr. Carion, are you learning from our discussion or not?
Yes, I'm learning, USEC. I'm continuing to learn.
Ikaw na lang ang pangutanan ng ubad. No? Kasi yung mga iba, mga kung ano yan sila mga professional na yan. May mga lawyers nga nag-attend ngayon There are many lawyers Acceptance is necessary to make the resignation effective. This is very important. Ito, there are many employers who are at fault. When there is a resignation, it just lays this. It lays there and it dies there. No action para itong application for leave. Meron nag-apply for leave. Tapos ito naman nag-apply for leave. O hindi niya hinintay yung acceptance. Halimbawa, nag-apply araw ng Thursday, next Monday mag-leave siya. Thursday, Friday, Saturday, walang action. Pagka Monday, dumiretso na siya. Pinailan siya ng awol. Bakit? Hindi inaccept yung leave mo Bakit ka? Why did you go on leave without acceptance? Maawol ka talaga, technical ka dyan. But on the part of management, from the HR point of view, there must be in San Miguel, nag-install ako ng mechanism. If an application for leave is not acted upon within 48 hours, it is deemed. But that is as a rule made by management. That's not a labor code. In the labor code, pag hindi pa, if the leave application is not approved, you should not go on leave. That would be without official leave. But in the case of resignation, your resignation is not effective unless and until it is accepted. And it should be accepted in writing. Even if it is just on top of the same letter, for instance, I tender my resignation as, then sign. Tapos, ibabaw, sulatan lang ng management, approve, effective, ganyan. Not necessarily yung effectiveness na sinabi niya doon sa baba, as long as effective February 4, 2021. Ang sabi ng management, approve, effective January 31. Yung management masunod yan kasi it is the 30-day notice is the right of management. Management can waive it. No? So, hindi yung, not necessarily yung dinictate na, but as long as there is an approval. That is what I'm saying. Do not assume that all resignation is approved just because it is not acted upon. No, unless if we want to be ISO talaga certified, we must have a timetable for actions. Commit ng offense, 30 days na, hindi pa tapos investigation, nakalimutan na niya anong ginawa niya. Then after 6 months, saka mo ilabas yung decision. Irresponsible management. Para sa akin, irresponsible management. If you are HR, ikaw magbigay ng deadline. Lahat ng mga trabaho, regularization of provisionary employment, no? Lahat na yan. Salary increase, no? Transfer of employees, disciplinary action. You must put a timetable because any action without timetable is a sign of irresponsibility on the part of management, especially HR. I'm demanding a lot from HR. Pag wala kayong mga deadline, yan ay dapat kayo mag-propose sa management, ipa-approve ninyo sa management. Sasabihin niyo, wala kasing deadline. Hindi ikaw gumawa, mag-propose ka. Do not expect that it will happen unless you make it happen. Kung hindi ikaw, sino pa? Kung hindi ngayon, kailan pa? Somebody must do it and you have to do it. Yung sinasabi ko sa iyo eh. Some issues related to resignation. Not giving the resigned employee resignation is not an evidence of constructive dismissal. Halimbawa, nag-resign na yan, naghintay na lang ng effectivity. Pwede nga sabihin ng management, you don't have to report for work. I'm not barred, you are not barred, you can still come here. But we are waiving, you don't have to report for work, you still have salary up to the end of the month, but you don't have to report for work kasi natakot ang management, baka magkuha ng mga data, kukunin yung mga software, or nakawin yung trademark or copyright or whatever. So, to protect management, pwede na yan. You don't have to report. It can be waived. Now, pwede bang magreklamo yung empleyado na that is a sign of constructive dismissal, hindi na ako binigyan ng trabaho? Ang sagot dyan, dapat ka pa nga magpasalamat. You should be thankful because you are given pre-ride, you can receive your salary, but you do not have to work. Because the giving of the work is the right of the employer, and the right can be waived. No? So do not compel the employer to give you work na on the last days, hindi ka na dapat kailangan bigyan pa ng trabaho. Magpahinga ka na. Prior to acceptance of resignation, an employer may still proceed. Ito ang sinasabi ko. If there is a pending case, we should make at a policy na huwag kang umalis sa kumpanya that there is a cloud of doubt in your name. If you are innocent, you will be exonerated. If you are guilty, you don't have to resign. You do not have to commit suicide. I will kill you, sabi ni Presidente. Pero hindi mo siya kasuhan kasi future daw siya. Sabi ni Presidente Duterte, pwede mo bang kasuhan ng Presidente? Future lang, I will kill you. Hindi naman niya sinabi, I have never killed anybody. Pero lagi niyang sinasabi, I will kill you. Pwede mo, can you punish a person for a future act? No. That is just that is a promise, no? Na hindi na fulfill. So dito, if there's a pending case, it's good for the employee. Sabi mo, iho, kung ako sa'yo, huwag kang mag-resign. Kasi pag ikaw ay mag-resign na with pending case, we will put in the certificate of employment, resign with pending case. We're not saying you are guilty, but you have a pending case. employer that there is a man who is applying for a job in your company and he left without completing the administrative process of investigation. And that is the right of the employer. That is the prerogative of the employer. If there's a pending case, we will finish this case, guilty or not guilty, so that if you are innocent, your certificate of employment is clean. You have no record. No? Yan ang sinasabi. There is a distinction between resignation of managerial employees and, on the other hand, and resignation of rank and file. The law is very strict against managerial and executives. In other words, yung mga managerial employees at executives who claimed that they were subjected to coercion, force. Iba mo sinasabing, pinilit lang po ako na pumirma. Paano tinutukan ka ba ng baril? Parang kwanto shotgun marriage Pero dineclare mo publicly. So, you are a manager. You are an executive. In the following cases, so tingnan mo yung number 5 dyan, Globe Telecom versus Crisologo. Yan ang sinasabi ko sa inyo. No? High ranks and high education are indicators of voluntariness. So, all those who have high rank, managerial and executive, they are presumed to know what they are doing. No? They cannot claim that they were hoodwinked, they were fooled, they were seduced into writing, they were misled. No? Kung mga librarian, construction worker, not even cannot sign their name correctly. No? They can allege that they were fooled. No? High ranks and high education. Yung bang sinabing, pag hindi ka mag-resign, papailan kita ng kaso. Is that a coercion? Will that qualify to annul or to invalidate? Because to file a case is a right. And if the management will say, I will exercise my right to file a case against you if you don't resign. You are given an option, resign or we will file a case. Will that kind of situation destroy the voluntariness of the resignation? The Supreme Court said no. Pero pag sinabing, pag hindi ka mag-resign, ipakulam kita sa sikihor or papatay kita, ayun ang masama. No? Tapos meron pa, nilabasan pa ng 45. Pero pag sinabing, we will file a case against you, that will not invalidate. Kasi okay, pag ikaw naman, tinakot ka, sige, filean mo ng case, make my day. Kasi wala rin mangyari sa kaso mo kasi wala kang mapatunay sa akin wala akong kasalanan, malinis ako That's why according to the Bible, no, those who are pure are bold as a lion. No? Siyempre matapang ka kasi malinis ka Pero pagka meron ka talagang ginawang kahit kunti o malaking kalukuhan, ay matatakot ka talaga ng kaso. Tapos magpirma ka, then later on, babalik na rin mo. Pareho nito, Kalyanta case. In audit, there was an audit and there were findings, adverse findings. Tapos sinabihan, if you do not resign, I will file a case of malversation, falsification of private documents, no, as immense to commit estafa. Yan ba? Will it destroy the voluntariness of the resignation? No. Because the employer has the right to say that. Yan, high rank and high education indicator of voluntariness. Ito, si Dumondon, holder pa ng AD, UST, MBA, University of Asia and Pacific, 2 years in the College of Law of Adamson, Vice President. Pero tapos sasabihin, involuntary resignation. Paano maniniwala ngayon yung Supreme Court? Vice President ka. Law student ka pa. MBA graduate ka. Maluloko ka ba? Executive Director ng AMCOR. Tapos, babae ito, she signed a resignation letter because of the amount she received. Maliitan sa amount. Tapos sabi, involuntary. Kasi nakatanggap siya 3 million, 3.7 million as voluntary resignation. And then later on, she will come back and say, I was forced to resign after you received 3.7 million. That is, he who comes to court must do so with clean hands. Every person in the exercise of his right and in the performance of his duty must act with justice, give everyone his due, and observe honesty and good faith. Meron mga tao talagang ganun. Ito, Globe Telecom. The employee was a lawyer, manager of the legal services, accomplished educational background, professional standing. So sabi ng Supreme Court, no lawyer would resign and then later on say that that was involuntary. No? Alam mo, yung sinasabi nung matanda, yung tinatawag na palabra de honor. Alam ba niyo yung word na palabra de honor? Word of honor. Yun nga, salita lang nga yun eh. Word of honor lang yun eh. No? Pag si Gokongwe manghilam ng 50 million kay Lusyutan, salita lang yun. Yun ang pipirmahan yun. Hiraman lang sila. Ito sa Binondo, dati yung sinasabing Binondo Central Bank, mga Chinese, maghiraman sila ng pera, 5 million, 10 million, walang perma. Salita lang. Pag hindi ka magbayad, patayin ka lang. O di, so madali lang. File ka pa ng kaso. No? High ranks and high education indicators of voluntariness. Guerson, export-import manager, chief accountant with high educational background. No? Yung mga pabalik-balik yan eh. Gun, in the case of Gun versus Galderma, the employee was a product manager with extensive experience in business transaction and negotiation. The Supreme Court did not believe that she was strict morally or psychologically. Yan. Sa Globe Telecom na naman yan. No? Kaso sa Globe Telecom. The language used can be a reliable gauge to show voluntariness. You know, the Supreme Court will look at the wording of the resignation. Alam niyo ang isang wording na salamat. Yung bang I thank the company for all the learnings that I got from my stint and para magpasalamat. The expression of gratitude is a gauge of voluntariness. Mag-resign ka, tapos magpasalamat ka sa management. Tapos kung ako ang management, pagka nag-resign and then he receives the separation pay or whatever, last salary or proportionate 13-month pay, picturean mo yung nakangiti. Picture. The picture will speak a thousand words. Yung picture magiging exhibit A yun eh. Sabi mo, tingnan mo yung mukha ng empleyado. Siya ba napilitan ba siya na mag-resign? Tingnan mo lang yung mukha. Makita ng arbiter yun. Kayong mga taga-HR, dapat pang kayo, handa kayo ng camera because camera is the best weapon of HR. Kunan yung picture. Total ngayon, lahat ng cellphone may camera na eh. Kunan yung cellphone, pagtanggap ng cheque, nakangiti. Paano mo sabihin niyang pinilit mo yan mag-resign? Language, the statements of petitioners were simple and straightforward. No? Kasi itong si Cervantes, kilala ko ito eh, husband ito ng classmate ko eh. Kapitan ng barko. Habang nasa South America siya, nagpadala siya ng telex. Telex pa nung araw eh. Na ang mga statement niya na very clear na nagre-resign siya. And then pagdating dito, he alleged that he was pressured kasi lahat ng mga tripulante nag-file ng petition laban sa kanya. Kapitan siya ng barko, pinag-initan siya. So, pagdating nag-file ng kaso, he lost the case before the Supreme Court. Said, you were not dismissed, you were not fired, you resigned. Your wordings are very clear. No? It was straightforward. So why do you complain? No? Kung sa mga Bisaya ba, ito yung sinasabing pamasin-basin ba, baka tayo makakuha ng separation pay or additional, baka management will succumb and will just negotiate for settlement. Nothing to lose because there is no yung sinasabing filing fee, no? The wording of resignation as indicator of voluntariness. Yan, paikot-ikot yan. Expression of gratitude, yan ang sinasabi. Alam mo yung lawyer na nag-resign, sinabi pa, I wish to express my appreciation for the training you gave me while I was under your supervision. That was considered as an indication of voluntariness. No? Exception to the rule. Meron namang exception to the rule. To rule that resignation letters couched in terms of gratitude are by themselves conclusive. Hindi yung conclusive. Kuan lang yun. Disputable presumption. It's not conclusive. Kasi you have to consider other circumstances, not just the wording of the resignation. Ang Supreme Court minsan, kung gusto nilang tulungan talaga, meron silang justification. Pag ayaw nila, naaangasan sila, i-justify nila, tulungan nila. But anyway, law is not an exact science. Sabi mo, sir, nakukonfuse ako eh. Talagang makukonfuse ka. At magpasalamat ka sa sarili mo na confuse ka. Bakit? Ibig sabihin, nag-iisip ka. Nakukonfuse ka eh. Yung mga hindi na-confuse, baka walang iniisip yun. Kaya nga kayo, pag na-confuse, sabi mo, sir, nakukonfuse na ako. Ano ba talaga? Pag gratitude ba talaga is an indication of voluntariness? Sabi mo, pag nag-answer ka, as a general rule, the Supreme Court in a long line of cases has declared that the expression of gratitude is an indication of voluntariness. However, there are exceptions to this rule when other circumstances are to be considered. Ano ang answer mo? Kompleto. No? Hindi yung one way ka lang. Yan. No? What happens if the resignation letter was prepared by the employer? Yan na naman, ha? That is an indication that it was involuntary. Especially if the wordings are high-sounding, very British high yung higher kind of English, no, na hindi ma-arok ng mga ordinaryong tao, no. Merong mga language ang mga lawyer na yung mga halata mo talagang lawyer ang gumawa, no. Ito mga ordinary worker ito, pagkatapos security guard ito prime security services, tapos ang resignation letter sobrang kaganda. Hindi na naniniwala ang Supreme Court yan, no. Those are indication na in the case yan, puro security. Can you read that, Mr. Carion?
Yes, USEC. Okay. In the case
In the
of
case of
Mobile
mobile. Sige.
Protective and Detective Agency versus OMPAD, the High Court agreed with the NLRC and Court of Appeals that the two resignation letters issued are dubious, to say the least. A bare reading of their contents would reveal that they are in the nature of a quitclaim, waiver, or release. They were written in a language obviously not of respondents and lopsided worded to free the employer from liabilities. Thus, it was held that voluntariness is not attendant in this case because the first resignation letter was a pro forma entirely drafted by the petitioner agency for the private respondent to freely affix his signature, and the second one was entirely copied by the private respondent with his own fund from the first resignation letter.
Ito, umpad. Ang respondent dito si umpad,
Mm.
no? So, yung pagkagawa overkill ba, ginandahan masyado ang English. Overkill na yon to the extent that it destroyed its credibility. So, para pagka na-overacting ka sa paggawa ng resignation letter and ginandahan mo masyado, patapos all the wordings lopsidedly, no, lopsidedly worded. So, masyadong pabor sa employer, no? Parang doon sa kanyang resignation letter ay ginib up na niya lahat ng kaluluwa niya, no? So, hindi naman niwala ang Supreme Court niyan. 'Yon ang sinasabing contract of adhesion. If you remember your obligation and contract, a contract of adhesion is one where the terms and conditions are all prepared by one party and the only participation of the other party is to affix his signature. Ano example dito? Yung mag-loan ka sa bangko. Pumunta ka sa bangko, papirmahin ka ilang pages, napakaliit na mga letters, mga sobrang haba, wala kang panahon magbasa at kung magbasa ka man, di mo maintindihan. And then you just sign it. That is contract by adhesion. And that is presumed to be involuntary if that is a resignation. Kasi all that is put there are not your words. These are the words put into your mouth, no? And you are just led to sign it. So that will be very strictly construed against the author of that contract. Ito, Mr. Carion, can you read that? When
Yes,
is resignation prepared by the employer considered binding?
yes, Jose. Okay. In the case of Samaniego versus NLRC, the employees agreed to resign instead of being involuntarily separated by reason of company reorganization by Sandvik Philippines Incorporated. After a series of negotiations, they were granted better benefits under the voluntary resignation option. Then they signed resignation letters on the ground that they were prepared by the employer, Sandvik. The court, however, ruled that in the absence of any evidence that the workers were coerced into resigning from their company, the fact that the resignation letters were prepared by the company does not make them invalid. Thus, although the resignation letters signed by the petitioners were apparently prepared by the company, it is important to note that the petitioners signed the same voluntarily.
So the important factor here, kapatid na Mr. Carion, is that the resigning employee did the resignation with knowledge, freedom, and voluntariness. With knowledge sa tatlo ha, knowledge, freedom, and voluntariness. In other words, yung knowledge means that you know what you are getting into. And freedom, you have the right to say no or to say yes. You have the freedom. And then having the knowledge and the freedom, you voluntarily, no? Voluntarily, hindi giniyahan yung kamay mo. Ikaw mismo talaga ang sumulat ng iyong perma. So, pag nandoon yung tatlo, ha, tandaan nyo yung tatlo. Knowledge, freedom, and voluntariness. Una, alam mo ba kung ano yung pinapasok mo? That's why, if you remember, kayong mga estudyante, pag ang isang akusado mag-plead guilty, ako alam ko yan, court interpreter ako eh. The judge, sabi ng akusado, nakapusas pa, judge, mag-plead guilty na lang ako. Alam mo ba, ang judge na matino, hindi niya kaagad tanggapin yan. Mag-isip-isip ka muna, iho. Kasi alam mo ba na pag ikaw ay nahatulan, baka ma-life sentence ka. Maximum. Alam mo ba, nagkonsulta ka na ba ng pamilya mo? Ganon talaga. Kasi we have to exercise extraordinary diligence. Kaya dapat alam mo ang pinasok mo bago ka pumirma. And you have the right to say no. Kung sinabihan ka ng abogado, aminin mo na lang para matapos na yan. Hindi ang abogado mo magdesisyon, ikaw pa rin, kaya babasahan ka. That is, kaya kaya may arraignment eh. Babasahan ka eh. The province of Cebu, the provincial prosecutor, the province of Cebu hereby accuses you of the crime of robbery with homicide committed as follows, that on or about the 4th of January 2021 at about 7:30 in the evening within the city of Cebu and within the jurisdiction of this court, you intentionally, with knowledge, freedom, and voluntariness, in conspiracy with, using superior strength and taking advantage of the darkness of the night. Ganon. Alam mo ako, memorize ko lahat yan eh. Kasi ako tagapagbasa ng mga information eh, as court interpreter. Kaya yan mga empleyado, ang mga HR na professional, hindi yung HR na sasabihin, sige mag-resign ka na para matapos na ito. Hindi. Ang HR na matino, sabihin na, iho, isip-isipin mo bago ka pumirma. Ayusin mo muna ang sarili mo. Baka mamaya sasabihin mo, pinilit ka namin. No? Sarili mo yan. Alam mo ba ang ibig sabihin ng resignation? 17 years ka na sa kumpanya, wala kang matatanggap na separation pay. Hindi ka entitled ng early retirement, wala ka pang 60 years old. Alam mo ba mawala sa iyo? Ganon. Kaya mga may-ari ng kumpanya, huwag kayo magalit pagka ganon. Kasi ang HR is a professional. He will tell the truth. Ngayon, ang ibig sabihin, binibigyan mo ng option ang tao, hindi mo ginigipit, hindi mo yung nilalagay mo sa ang kanyang likod na sa pader, na wala na siya ibang mapupuntahan, surrender na siya, aminin niya lahat. So, ganon yan. Ang importante yung nasa baba. At the end of the day, the bottom line is this. Did the employee sign this with knowledge? Naintindihan mo yung knowledge, maaaring alam mo pero hindi mo naintindihan. Knowledge means not only knowing but understanding. Understanding not only the act but the implications and the consequences of the act. And then next, you have the freedom to say yes or no. And number 3, you exercise your free will to make that decision. Ganon yun. Ladies and gentlemen, it's 8 o'clock in the evening. We have a long topic and we still have a lot of cases. I know that this is more than 200 slides and I think that this deserves another round, one good start for the year 2021 deserves another round. So do you have any objection if we will adjourn and come back? If ever for you to come back, it's not compulsory, but ito naman ay mga voluntary. I welcome Mr. Alex Chua. Kaibigan ko yan, si Alex Chua, na matagal nagbigay ako ng kanyang mga seminar sa kanyang company. Nandito pala si Attorney.
Good evening, Attorney.
Mayang gabi, nandito si Attorney Ramil Sungkad. Oh, yan, nabanggit ko yan si Ramil. Nanalo na yan sa marami ng kaso, pinanalo yan si Ramil sa Supreme Court. Kahit yung kaso ng Pepsi Cola sa Tacloban, pinanalo niya. Nandito yata si John Padilla din, no? From Pepsi Cola, no? Marami dito mga tao. Nandito si Mr. Earl Barito, si Mr. Norman nandito, no? Si Attorney Storgio nandito. Maraming tao na ngayon nakarating ngayon dahil talagang binigyan ko ito ng promotion, Attorney Wagas. No, ako ang nag-text sa kanila.
Yes, Attorney.
At mabuti naman na nakarating tayo dito kasi ganado tayong magbigay ng passionate na lecture pag marami ang nakinig. Minsan kasi kunti lang, parang wala tayong gana. Nandito si Neil Sakay, future congressman of the Lone District of Ifugao, no? Nandito lahat. Nandito si mga taga-dilatory company. Marami tayong mga kaibigan, no, na nandito. Hindi ko na isa-isa lahat. I thank you for your trust and confidence. Si Ma'am Valerie at sa kanyang staff sa HR at si Mr. Norman Forbes sa kanyang mga kasamahan at iba na nandito. Maraming salamat. In Cebu, we say daghang salamat. Dito si Mr. and Mrs. Dr. Adolfo at saka si Ning Adolfo at sa lahat na nandito. Sa
Thank
iyo,
you, Attorney USEC. Salamat po.
Maraming salamat.
Daghang salamat po.
Balik-balik kayo sa next Monday, the same time. Marvin.
Opo.
Dr.
Opo.
Marvin.
Salamat po, Attorney.
Opo.
Salamat po.
Maraming salamat. And,
Daghang
see you
salamat,
next
Attorney.
time.
Daghang salamat.
Okay.
Thank you, Attorney. Thank you very much, Attorney.
Thank you.
Picture.
Picture ta. I will i-stop share ko na para ma-picture tayo. Huwag mo na kayong umalis para mag-picture tayo lahat, no? Bisag wa pay panihapon, mag-picture. O naman si John Lloyd. Si John Lloyd sa tabi ni Bia.
1, 2, 3, smile. Okay. Next slide. Steady lang ha, guys. 1, 2, 3, smile. Right.
Mr. Carrion, Dan. Daghang salamat, Dan.
Yes, USEC. No problem, USEC.
Okay na, USEC. Thank you.
Sa sunod, tapusin natin ito. Marami pa tayong topic. No?
Yeah.
May problema
And we
Yusek, iwas
will
yun na.
use the same link, everyone. So sa next
Okay.
week, gamitin nyo lang yung same link.
Same link
Same
yapon.
link. No?
Yes.
Thank you po.
Thank you po, everyone.
Maraming
Thank
Happy
you.
New Year sa tanan, Happy New Year sa tanan. Happy New Year sa lahat.
Okay.
Thank you, Ma'am Mitch. Thank
Happy
you.
New Year.
Thank you, USEC. Thank you, Attorney Wagas. Thank you,
As
Thank
UB.
you.
usual. Amping kanunay Yusek, amping kanunay.
Amping aron dili malumping.
Attorney JB.
Oh, salamat Neil. Meron taga Dubai di ka Neil. Mr. Alex, Merry Christmas na lang nimo diha.
Yeah, Happy New Year.
Okay, I hope you invited your friend. Anyway.
Yeah. Some of my friends, I saw their names. Yeah.
Salamat nila, no?
Okay, thank you, Kayo. Thank you sa invite.
Salamat,
Okay,
Mr.
okay.
Alex.
See you next week.
Okay, thank you.
Okay, thank
See you
you.
next week, everyone. Have a good evening. Thank you, Attorney Menes.
Thank you.
New Year.
Wala ngayon si Ma'am. Wala si Ma'am. Kung ano no?
Si Dr. Crispy. Wala siya, attorney. Murag na busy siya, attorney, kay pag bumalik sa school pa.
Okay. Thank
Next week,
you.
attorney. Yes, attorney.
Yung aking sinabi ha, pwede tayo mag-symposium.
Yes, attorney.
Okay.
Ako lang to i-set up with Dean, attorney, for
Okay. Thank you.
the date.
Good night, USEC. Good night, Attorney Wagas.
Thank you, Doc. Cora. Doc, next week.
Thank you,
Doc.
Attorney Wagas.
Sige, Attorney.
Mr. Marvin. Thank you, everyone. I'll end this. See you with the same link next week. Have a good evening.